The courtroom fell silent as Judge Meredith Ross leaned forward, her reading glasses catching the fluorescent light. Her hand hovered over a manila folder marked Exhibit 12, Exgeme, Not Admitted. Outside, Lake Michigan's winter wind rattled the courthouse windows. Inside, 47 people held their breath.
"I'm going to do something," Judge Ross said quietly, "that may cost me this case on appeal. What happens when a judge sees the truth but the rules say she can't use it? What happens when the system designed to protect the innocent becomes the very thing that might condemn them? This is the story of a decision made in 3 seconds that took 20 years of legal experience to reach. A decision that broke a procedural rule to serve a higher principle. A decision that would be debated in law schools, scrutinized by appellate courts, and questioned by every person who believes justice should be blind but not deaf. The defendant was a 32-year-old woman named Elena Cruz, accused of aggravated assault with a deadly weapon. The alleged victim was her former supervisor, Marcus Whitmore, who claimed she attacked him with a kitchen knife in the parking lot of a convenience store at 9:47 p.m. on February 9th. Whitmore suffered a deep laceration across his left forearm, requiring 18 stitches. The state's star eyewitness, a neighbor named Gerald Reed, swore under oath he saw Elena Cruz stab Whitmore unprovoked, then flee the scene. The evidence seemed overwhelming. The testimony seemed airtight, and Elena Cruz, a single mother working 2 jobs to support her 7-year-old daughter, faced 8 to 15 years in state prison. But at 2:37 p.m. on the 4th day of trial, 90 minutes before closing arguments, a police officer named Blake knocked on the courtroom door, carrying a flash drive that wasn't supposed to exist. Judge Meredith Ross had presided over 417 criminal trials in her 19 years on the bench. She had sent gang leaders to life sentences and exonerated the wrongly accused. She had been reversed on appeal twice, once for an evidentiary ruling, once for a sentencing miscalculation. She wore her black robe like armor and her reputation like a shield. Colleagues called her fair but strict, compassionate but unbending when it came to procedure. And now she was about to throw procedure out the window. "Your Honor," defense attorney David Carter was saying, his voice urgent but controlled. "This evidence was obtained legally. It's directly relevant to the core issue of identification, and the only reason it wasn't produced earlier is because no one knew it existed until yesterday." District Attorney Carla Nguyen stood immediately. "Your Honor, discovery closed 3 weeks ago. The rules exist for a reason. This is a transparent attempt to ambush the state on the eve of closing arguments. We object strenuously to any consideration of this so-called evidence." Judge Ross looked at the flash drive sitting on the bench before her like a small explosive device. She looked at Elena Cruz, sitting perfectly still at the defense table, hands folded, eyes down. She looked at the jury box, empty now during this bench conference, and she looked at the clock. In 90 minutes, she would instruct the jury. In 90 minutes, 12 strangers would begin deliberating whether Elena Cruz was a violent criminal or a victim of mistaken identity. And Judge Ross knew something they didn't. She knew what was on that flash drive, and she knew that if she admitted it, she might be handing the state grounds for a reversal. But if she excluded it, she might be sending an innocent woman to prison. This is the story of that choice. This is the story of what happens when the letter of the law and the spirit of justice go to war in a single human heart. This is the story of the judge who broke a rule to serve justice. Let's go back to the beginning. Elena Cruz never wanted to be in a courtroom. She wanted to be in her daughter Sophia's second-grade classroom for the spring concert. She wanted to be at her job at the packaging facility, earning $17 an hour. She wanted to be anywhere but sitting at a defendant's table wearing a borrowed blazer, listening to a prosecutor describe her as dangerous, violent, and deceptive. The charge was aggravated assault with a deadly weapon under Illinois Statute 720 ILCS 512-2. In plain English, that means causing bodily harm to another person using an object capable of causing death or great bodily harm. The deadly weapon in this case was a 7-inch kitchen knife with a black handle. The bodily harm was a laceration that ran from Marcus Whitmore's wrist to his elbow, severing muscle and narrowly missing an artery. The penalty range was 3 to 7 years in prison. But because Whitmore was Elena's former supervisor and the state argued there was a power dynamic at play, District Attorney Nguyen was pushing for the aggravated range of 8 to 15 years. Why would Elena Cruz stab her former boss in a convenience store parking lot? According to the prosecution's theory, revenge. Marcus Whitmore had fired Elena from her job at a medical supply warehouse 6 weeks before the incident. He claimed she had been chronically late, made errors in inventory, and been insubordinate when confronted. Elena claimed she had been fired for refusing Whitmore's repeated advances and for reporting his behavior to human resources. The HR complaint was real. It was filed on January 14th. Elena was terminated on January 23rd. 9 days later, Human Resources concluded there was insufficient evidence to substantiate Elena's claims. Marcus Whitmore remained employed. Elena Cruz did not. And on February 9th, 17 days after that HR decision, Marcus Whitmore was stabbed in a parking lot. The prosecution's narrative was simple and compelling. A woman, scorned, humiliated, and unemployed, saw her abuser face no consequences. She snapped. She armed herself. She waited for him. And when the opportunity came, she attacked. David Carter, Elena's public defender, told a different story. He said Elena was home that night with her daughter. He said she had never owned a knife matching the description of the weapon. He said Marcus Whitmore had a history of volatile relationships and had been involved in 2 prior domestic disturbance calls. He suggested that someone else attacked Whitmore, and that Whitmore, knowing Elena had accused him of harassment, saw an opportunity to retaliate by naming her as his attacker. 2 stories, diametrically opposed, and in the American criminal justice system, the burden of proof lies entirely with the prosecution. They must prove Elena's guilt beyond a reasonable doubt. She doesn't have to prove her innocence. She doesn't have to testify. She doesn't have to offer an alternative theory. The state must build a case so strong that no reasonable person could doubt it, and for 3.5 days of trial, it looked like they had. The state called 6 witnesses. First, Marcus Whitmore himself. He testified that on the evening of February 9th, he stopped at the Quick Mart on South Halsted Street around 9:30 p.m. to buy cigarettes. As he was walking back to his car, he heard footsteps behind him. He turned and saw Elena Cruz running toward him with a knife raised. He put up his left arm defensively. She slashed him. He fell. She ran. He called 911. Under cross-examination, David Carter pressed Whitmore on whether he was certain about the identification. The parking lot was dimly lit. The attack happened quickly. Was he absolutely sure it was Elena Cruz? Whitmore didn't hesitate. "I saw her face," he said. "I worked with her for 9 months. I know what she looks like. It was her." The second witness was Gerald Reed, the neighbor who became the state's star. Reed lived in an apartment complex across the street from the Quick Mart. He testified that on the night in question, he was sitting on his balcony smoking a cigarette when he heard shouting. He looked over and saw, clearly under the parking lot lights, a woman with dark hair and a ponytail stab a man and then run toward a side alley. He didn't know Elena Cruz personally, but 3 days later, when police showed him a photo array of 6 women, he identified her without hesitation. "I'm good with faces," Reed said on the stand. "I saw what I saw." Under cross-examination, Carter got Reed to admit he was approximately 70 feet away, that he was not wearing his prescription glasses at the time, and that the woman he saw was on screen for perhaps 8 to 10 seconds before she disappeared into the alley. But Reed was unshakable. He saw her. He was sure. The third witness was Officer Jamal Thompson, the responding officer who took Whitmore's initial statement at the scene and later interviewed Elena Cruz. Thompson testified that when he and his partner went to Elena's apartment at 11:15 p.m. that same night, Elena answered the door in sweatpants and a t-shirt. She seemed surprised. She denied being at the Quick Mart. She said she had been home all evening with her daughter. Thompson said her demeanor was calm, almost too calm for someone being accused of a violent felony. The fourth witness was the emergency room doctor who treated Whitmore. He described the wound as consistent with a slashing motion from a sharp blade, likely a kitchen knife or similar instrument. The wound required internal sutures, external stitches, and antibiotics. Whitmore was lucky, the doctor said. 2 inches higher and the blade might have severed the brachial artery. He could have bled out in minutes. The fifth witness was a forensic analyst who examined the knife recovered 3 days after the attack. A custodian found it in a dumpster 2 blocks from the Quick Mart. The knife had been wiped clean, no usable fingerprints. But there were microscopic traces of blood in the handle's grooves. DNA testing matched the blood to Marcus Whitmore. The analyst couldn't say who wielded the knife, only that it was almost certainly the weapon used in the attack. The sixth witness was Detective Laura Enriquez, the lead investigator. She walked the jury through the investigation, the 911 call, the witness interviews, the photo array identification, the search for the weapon, and ultimately the decision to charge Elena Cruz. Enriquez acknowledged that no physical evidence directly tied Elena to the knife. No surveillance footage captured the attack. No forensic evidence placed Elena at the scene. But the combination of the victim's identification, the eyewitness corroboration, and the context of the recent termination and harassment complaint created, in her professional opinion, probable cause to believe Elena Cruz committed the crime. That was the state's case. Motive, opportunity, victim identification, and independent eyewitness corroboration. It was circumstantial, yes, but circumstantial evidence is not weak evidence. It's simply evidence that requires the jury to infer a conclusion. And juries convict on circumstantial evidence every day. David Carter knew he was in trouble. He put on a modest defense. He called Elena's daughter's babysitter, who testified that she dropped Sophia off at Elena's apartment at 7:15 p.m. on February 9th, and that Elena seemed to be settling in for a quiet night. He called a former co-worker of Whitmore's who testified that Whitmore had a temper and had once thrown a clipboard across the warehouse floor during an argument. He entered into evidence the HR complaint Elena had filed, showing a pattern of alleged harassment. But he didn't call Elena herself. The risk was too great. If she testified, the prosecution could cross-examine her about every detail of her story, and any inconsistency, any hesitation, any perceived dishonesty could be fatal. The Fifth Amendment protects a defendant's right not to testify, and the jury is instructed not to draw any negative inference from that silence. In reality, juries always wonder, if she's innocent, why not say so under oath? By the end of day 3, both sides had rested. Closing arguments were scheduled for the following afternoon. Judge Ross sent the jury home and retreated to her chambers to prepare her jury instructions, those critical statements of law that guide jurors in how to apply the evidence. She felt uneasy. The case was legally sufficient. The state had presented enough evidence to survive a motion for a directed verdict. A reasonable jury could find guilt beyond a reasonable doubt. But Ross had been doing this long enough to sense when something was off. The pieces fit together too neatly. The eyewitness was too certain. The victim's story had no gaps, no hedges, no normal human uncertainty. And Elena Cruz, sitting silently at the defense table for 3 days, radiated something Ross had learned to recognize over 19 years. The particular kind of stillness that comes not from guilt and fear of being caught, but from innocence and terror of not being believed. Still, judges don't decide guilt or innocence in jury trials. Judges referee. They ensure the rules are followed, the evidence is proper, and the legal standards are met. The jury decides the facts. Judge Ross went home that night and didn't sleep well. The next morning, day 4, was supposed to be simple. A few housekeeping matters, jury instructions conference, then closing arguments at 1 p.m. Deliberations would likely begin by 3. A verdict could come that same day or stretch into the weekend. But at 9:45 a.m., David Carter filed an emergency motion. And at 2:37 p.m., Officer Blake knocked on the courtroom door with a flash drive. And everything changed. Let's talk about the rules. Because if you're going to understand why Judge Ross's decision mattered, you need to understand the system she was operating within. Criminal trials are governed by strict procedural rules designed to ensure fairness. One of the most important sets of rules concerns discovery, the process by which both the prosecution and defense exchange information before trial. Discovery rules exist to prevent surprise, to allow both sides to prepare, and to ensure that trials are decided on evidence, not on ambush. In Illinois, criminal discovery is governed by Supreme Court Rules 412 and 413. The prosecution must disclose to the defense the names and addresses of witnesses it intends to call, any written or recorded statements, any physical evidence, any scientific reports, and anything else that might be material to the case. The defense has similar obligations, though narrower because of the defendant's Fifth Amendment rights. There are deadlines. Discovery requests must be made within a certain window. Responses must be provided within a certain window. And there's a principle called the discovery cutoff, the point at which both sides are done exchanging information, and the case is locked in for trial. In Elena Cruz's case, the discovery cutoff was February 25th, 2 weeks before trial began. By that date, the prosecution had turned over everything it had: police reports, witness statements, forensic reports, photographs. David Carter had provided his witness list and disclosed his theory of defense. The deal was done. No new evidence. No surprises. Except that on the evening of March 13th, the day before closing arguments, David Carter received a phone call from Officer Blake. Blake was a patrol officer who had been part of the initial response team on February 9th, but had not been called as a witness. He explained to Carter that earlier that day, while doing an unrelated follow-up at the Quick Mart, he had gotten talking with the store's assistant manager. The assistant manager mentioned that after the stabbing incident, corporate had requested all surveillance footage from that night. Blake, curious, asked if he could see it. The assistant manager explained that the store's internal cameras didn't capture the parking lot. But then he remembered something. The store had recently installed a new camera on the rear loading dock to deter theft. That camera faced east. The parking lot was to the southeast. It was a long shot, but maybe it caught something. The assistant manager pulled up the footage. Blake watched, and at 9:41 p.m. on February 9th, 6 minutes before Marcus Whitmore said he was attacked, the camera captured a figure moving through the edge of its frame in the parking lot. The resolution wasn't great, the angle wasn't perfect, but the timestamp was clear, and the figure was clear, and the figure was not Elena Cruz. Blake immediately called Detective Enriquez. Enriquez told him to secure the footage and bring it to her. But Enriquez was in court that day on another case and didn't get back to the precinct until after 6 p.m. By then, she had missed the window to notify the prosecution. She called District Attorney Nguyen, who was at home preparing her closing argument. Nguyen told Enriquez to sit tight until morning. But Blake, who had met Elena Cruz during the initial investigation and had always felt something was off about the case, decided to make another call. He called David Carter's office. Carter's paralegal gave him Carter's cell number, and at 8:17 p.m. on March 13th, Officer Blake told the defense attorney about a piece of evidence that could change everything. Carter spent 3 hours that night reviewing the footage Blake agreed to copy for him. Then he spent 2 more hours researching case law on late evidence admission, and at 6:30 a.m. on March 14th, he filed a motion titled, Emergency Motion to Admit Newly Discovered Evidence. When court convened at 9 a.m., Carter stood before Judge Ross and made his case. He explained how the footage came to light through no fault of either party. He explained that it was clearly material and directly relevant to the issue of identification. He explained that the reason it wasn't discovered earlier was because no one, not the police, not the prosecution, not the defense, knew the Quick Mart had a rear loading dock camera. It was pure chance that it came to light at all. Your Honor, Carter said, the interests of justice require that this evidence be admitted. It goes to the heart of the case. Carla Nguyen was on her feet immediately. Her objection was forceful and grounded in procedure. Discovery had closed weeks ago. The defense had every opportunity to investigate the scene, to canvass for cameras, to subpoena footage. If they failed to do so, that was not the state's problem. Moreover, the footage was not in the state's possession until yesterday evening, and even then, the state had an obligation to review it and determine its relevance before deciding whether to disclose it. The fact that Officer Blake had gone rogue and delivered it directly to the defense was improper and potentially a violation of prosecutorial protocols. Your Honor, Nguyen argued, if we allow this, we open the door to endless trial by ambush. The rules exist to create a fair playing field. The defense cannot spring new evidence on the eve of closing arguments and expect the state to simply accept it. Judge Ross took the flash drive into her chambers and watched the footage herself. It was 18 seconds long. Time-stamped February 9th, 2024, 21:41:03 to 21:41:21. The camera was mounted high on the loading dock, angled down and to the east. The parking lot was in the far right of the frame, partially obscured by a dumpster. At 21:41:06, a figure entered the frame from the south, walking quickly. At 21:41:14, a second figure appeared, moving from the west. The two figures converged near a parked sedan. There was a brief interaction, maybe 4 seconds. One figure raised an arm. The other recoiled. The first figure moved away rapidly toward the alley at 21:41:18. The second figure stumbled, fell partly out of frame, then reappeared crawling toward the sedan. The quality wasn't high definition, but it was adequate. And there were 3 things Judge Ross could clearly see. First, the timestamp, 9:41 p.m. Whitmore said the attack happened at 9:47 p.m. This was 6 minutes earlier. Second, the sequence of events. It looked consistent with an attack. Third, and most critically, the attacker's appearance. The figure moved quickly, but not so quickly that details were lost. Dark pants, light-colored hoodie, and here was the key: hair visible beneath the hood, short hair, possibly male, possibly someone other than Elena Cruz, who had long, dark hair she typically wore in a ponytail. Judge Ross watched it 4 times. Then she read Carter's motion. Then she read Nguyen's opposition. Then she sat in her chambers, staring at her bookshelf, at the leather-bound volumes of Illinois case law, at the framed photo of her swearing-in ceremony 19 years ago. The law was clear. Late evidence is disfavored. Discovery rules exist for a reason. Courts have repeatedly held that parties must exercise due diligence in investigating their cases, and lack of diligence is not grounds for relaxing procedural rules. But there are exceptions. Courts recognize that sometimes, despite everyone's best efforts, critical evidence comes to light late. When that happens, judges have discretion to admit it if 3 conditions are met. The evidence is material, the late disclosure was not due to bad faith or neglect, and the prejudice to the opposing party can be mitigated. Was the footage material? Undoubtedly. It potentially contradicted the timeline and identification. Was the late disclosure due to bad faith or neglect? No. No one knew the camera existed. Could the prejudice to the state be mitigated? Here was the problem. Closing arguments were scheduled for 1 p.m. It was now 10:30 a.m. If Ross admitted the footage, Nguyen would need time to investigate it, possibly recall witnesses, possibly revise her entire closing strategy. That would mean a continuance, possibly several days. It would mean the jury, which had already been deliberating the case in their minds, would go home and have even more time to form opinions. It would disrupt the trial's momentum. And there was another issue. If Ross admitted the evidence and the jury acquitted, the state couldn't appeal an acquittal. Double jeopardy would bar any retrial. But if Ross admitted the evidence and the jury still convicted, the state could appeal Ross's evidentiary ruling. An appellate court might find that admitting such late evidence was an abuse of discretion, reverse the conviction, and order a new trial. Elena would have won at trial only to face prosecution all over again. On the other hand, if Ross excluded the evidence and the jury convicted, Elena could appeal, arguing ineffective assistance of counsel or newly discovered evidence. But those appeals are hard to win, especially when the evidence was technically available to the defense before trial if they had looked hard enough. Judge Ross realized she was in an impossible position. If she followed the rules strictly, she might send an innocent woman to prison. If she bent the rules, she might trigger an appeal that would undo everything. She called both attorneys into chambers at 11:15 a.m. She told them she needed to hear arguments on the record. She reconvened court in an empty courtroom, no jury present, and listened for 90 minutes as Carter and Nguyen waged war over 18 seconds of surveillance footage. Carter argued that the footage raised reasonable doubt. If the attack happened at 9:41 and not 9:47, then Whitmore's timeline was wrong. If the attacker had short hair, then Reed's identification was wrong. If both those things were wrong, then the entire case collapsed. Nguyen argued that the footage was inconclusive. The timestamp could be incorrect. Security cameras are notorious for time drift. The figure's hair length was unclear. The angle was poor. And even if it showed an attack, it might not be the same attack. Maybe there were 2 incidents that night. Maybe Whitmore was confused about the exact time. The footage didn't exonerate Elena. It just muddied the water. And muddying the water after the trial was essentially over was precisely what the discovery rules were designed to prevent. Judge Ross listened. She asked questions. She took notes. And then, at 1:53 p.m., she made her ruling. "I'm going to admit the evidence," she said. The courtroom seemed to tilt. Nguyen's face went pale. Carter exhaled like he'd been holding his breath for a year. But Ross wasn't done. "However," she continued, "I'm doing so under very specific conditions and with a very specific understanding. Miss Nguyen, you will have until 9 a.m. tomorrow to review the footage, consult with your witnesses, and determine if you wish to reopen the state's case. Mr. Carter, if the state reopens, you'll have the same opportunity. We will reconvene tomorrow at 9 a.m. If neither side wishes to present additional evidence, we will proceed to closing arguments at 10 a.m. The jury will be instructed that this evidence came to light after the close of the case and that they should not draw any negative inference against either party for its late discovery. I am also going to include in my instructions a specific caution about the weight to be given to surveillance footage, particularly regarding the reliability of timestamps and image quality. She paused, looked at both attorneys, and then said something she rarely said from the bench. I am admitting this evidence because I believe the interests of justice require it. I am aware that this decision may be scrutinized on appeal. I am aware that I am exercising discretion at the outer boundary of what appellate courts typically accept, but I am also aware that this trial is not a game. It is not an academic exercise in procedural compliance. It is a process by which we attempt, imperfectly, to determine the truth and render justice. And if there is evidence that materially bears on that truth, and that evidence came to light through no one's fault, I cannot in good conscience exclude it simply because the timing is inconvenient. She looked at Elena Cruz, who was crying silently, hands over her face. We're adjourned until 9 a.m. tomorrow. That night, Chicago legal blogs exploded. Word of the ruling had leaked. Some commentators praised Judge Ross for putting justice above procedure. Others condemned her for judicial activism and predicted a swift reversal on appeal. One prominent defense attorney called it the gutsiest ruling he'd seen in a decade. One former prosecutor called it a dangerous precedent that would encourage sloppy investigation and trial by ambush. Judge Ross went home, poured a glass of wine, and sat in her dark living room wondering if she'd just destroyed her reputation for a case she wasn't even sure about. Because here's the thing, the footage didn't prove Elena was innocent. It raised questions. It created doubt. But it wasn't a video of someone else confessing to the crime. It wasn't a smoking gun. It was 18 seconds of grainy, ambiguous imagery that could be interpreted a dozen ways, and Judge Ross had just bet her career on 18 seconds. The next morning, District Attorney Carla Nguyen stood before Judge Ross and announced that the state did not wish to reopen its case. She had reviewed the footage extensively. She had consulted with Detective Enriquez and Officer Thompson. She had even brought in a digital forensics expert overnight to analyze the timestamp. The expert's opinion: the camera's internal clock was off by approximately 6 minutes. This was common in older surveillance systems that didn't regularly sync with network time servers. If you adjusted for that drift, the footage was entirely consistent with an attack at 9:47 p.m., exactly when Whitmore said it occurred. As for the attacker's appearance, Nguyen argued it was simply too unclear to draw any definitive conclusions. The figure could have had hair tucked into the hoodie. The lighting created shadows. The angle distorted proportions. Yes, it looked like it might be someone other than Elena Cruz. It also might be Elena Cruz on the worst video quality imaginable. Your Honor, Nguyen said, we stand by our case. The footage does not change the fundamental evidence. Marcus Whitmore identified his attacker. Gerald Reed corroborated that identification. The defendant had motive. The jury will evaluate all of the evidence, including this footage, and we're confident they will reach the right conclusion. David Carter also declined to reopen his case. He had what he needed. The footage would be Exhibit 12. The jury would see it, and Carter would argue in closing that it created reasonable doubt. At 10:07 a.m., Judge Ross brought the jury back into the courtroom. She explained that new evidence had come to light after the close of testimony, that she had reviewed it and determined it was admissible, and that they would now see it as Exhibit 12. She gave them the cautionary instruction about surveillance footage reliability. And then the bailiff dimmed the lights and played the 18 seconds on the courtroom's projection screen. The jurors watched in silence. Some leaned forward, some squinted, some took notes. When it was over, the lights came back up, and Judge Ross nodded to the attorneys. Closing arguments, she said. Miss Nguyen, you may proceed. Carla Nguyen stood and walked to the jury box. She was a 12-year veteran prosecutor with a conviction rate north of 80%. She knew how to tell a story. She knew how to take a jury's uncertainty and turn it into confidence. Ladies and gentlemen, she began, you've just seen 18 seconds of footage that the defense wants you to believe changes everything. I'm here to tell you it changes nothing. She walked them through the state's case again, piece by piece. Motive. Elena Cruz had accused Marcus Whitmore of harassment, been fired, and seen him face no consequences. Opportunity. She had no alibi except her own word and a babysitter who saw her at 7:15 p.m., more than 2 hours before the attack. Identification. The victim identified her. An independent witness identified her. And the defense had offered no alternative explanation, no other suspect, no reason why these two people would lie. The defense wants you to believe this footage shows someone else attacking Marcus Whitmore, Nguyen continued. But even their own expert can't tell you who's in that video. Even they can't tell you definitively that it's not Elena Cruz. What they can do is create confusion. What they can do is throw up smoke and hope you lose sight of the facts. She pointed to the timestamp on a freeze frame of the footage, projected on the screen. 9:41 p.m. But we know security camera clocks drift. We know they're not perfectly accurate. Our expert confirmed that this camera was off by 6 minutes. Adjust for that, and the attack happened at 9:47 p.m., exactly when Marcus Whitmore said. She paused, making eye contact with each juror. The defense wants you to doubt. That's their job. My job is to remind you of what you know to be true. You heard Marcus Whitmore testify. You looked him in the eye. You heard the pain in his voice. You saw the scar on his arm. He didn't make this up. Gerald Reed didn't make this up. They told you what they saw, and what they saw was Elena Cruz committing a violent crime. Nguyen spoke for 42 minutes. She was methodical, persuasive, and relentless. When she sat down, several jurors were nodding. Then David Carter stood. Carter was younger than Nguyen, less experienced, and working with a fraction of the resources. He was a public defender handling a caseload of 73 clients. But he believed in Elena Cruz, and that belief carried him to the jury box. 18 seconds, he said quietly. That's all it took to prove that everything you've heard from the state is built on sand. He didn't shout. He didn't pace. He stood still and spoke like he was talking to friends. The state wants you to believe that security camera was 6 minutes off. Maybe it was. Or maybe Marcus Whitmore was mistaken about the time. Maybe when you're bleeding and terrified, you don't check your watch. Maybe the attack happened at 9:41, and Whitmore, in his trauma, remembered it as 9:47. He advanced to the screen, where the freeze frame still showed the figure in the hoodie. Look at this person. Really look. The state says you can't tell who it is. I agree. You can't tell who it is. But you can tell who it isn't. Look at the build. Look at the height relative to that dumpster, which we know is 4 feet tall. This person is taller than Elena Cruz. This person's hair is shorter than Elena Cruz's. This person moves differently than Elena Cruz. Carter turned back to the jury. Gerald Reed sat on a balcony 70 feet away without his glasses and identified Elena Cruz from a photo array 3 days later. How reliable is that? Marcus Whitmore was attacked at night in a dimly lit parking lot by someone he claims is a former employee he hadn't seen in weeks. How reliable is that? He walked slowly along the jury box. The state has no physical evidence. No fingerprints, no DNA, no forensics tying Elena to the weapon. What they have is 2 people who say they saw her, and now you have 18 seconds of video that suggests they might be wrong. Carter's voice grew quieter, more intense. The state's burden is proof beyond a reasonable doubt, not beyond any doubt, not absolute certainty, but reasonable doubt. And I'm asking you, is it reasonable to doubt that Elena Cruz committed this crime, when the timeline doesn't quite fit, when the eyewitness didn't have his glasses, when the victim might be mistaken, when there's video of someone who might not be her? He stopped in front of the jury box and looked at each of them. Reasonable doubt isn't just a legal standard, it's a moral one. It's the system's way of saying we would rather let a guilty person go free than convict an innocent one. Because once you convict Elena Cruz, you take her daughter's mother away. You take 8 to 15 years of her life, and you can't give that back if you're wrong. He returned to his seat. The state hasn't proven Elena Cruz guilty beyond a reasonable doubt. That 18 seconds of video is all the reasonable doubt you need. I'm asking you to find her not guilty. Thank you. The courtroom was silent. Judge Ross looked at the clock. 12:31 p.m. She instructed the jury on the law, carefully explaining reasonable doubt, the presumption of innocence, the state's burden of proof, and how to evaluate circumstantial evidence. She explained that they must consider all the evidence, including Exhibit 12, and that they could not speculate or guess. At 1:15 p.m., the jury filed out to begin deliberations, and then came the waiting. Anyone who's been through a criminal trial will tell you the wait for a verdict is agony. For the defendant, it's the slow tick of a clock counting down to either freedom or prison. For the attorneys, it's second-guessing every question, every objection, every strategic choice. For the judge, it's watching the door and wondering if you made the right calls. Judge Ross returned to her chambers and tried to work on other cases. She couldn't focus. She kept thinking about the footage. She kept thinking about Elena Cruz's face when the jury was brought in that morning. the mixture of hope and terror. She kept thinking about what would happen if the verdict was guilty and the state appealed her ruling. An appeals court could easily find she'd abused her discretion. Late evidence admission is reviewed under an abuse of discretion standard, which gives trial judges significant leeway. But there are limits. And Judge Ross knew she'd pushed right up against them. If the case went up to the Illinois Appellate Court, she'd have to explain her decision in a written response. She'd have to defend her reasoning in legal briefs, and there was a real chance they'd reverse. But here's the thing about appellate courts. They don't see the people. They read transcripts. They review legal arguments. They apply precedents. They don't see Elena Cruz's hands shaking as she sits at the defense table. They don't see the 7-year-old girl in the gallery who might lose her mother. They don't feel the weight of the gavel or the silence of a courtroom holding its breath. Judge Ross had made a decision based not just on law, but on conscience, and now she had to live with whatever came next. At 3:47 p.m., there was a knock on her chamber door. Her clerk entered. "Your Honor, the jury has a question." Ross's stomach dropped. Jury questions can mean anything. Confusion about the law. A request to review evidence. Deadlock. She returned to the courtroom. The attorneys were already there, Elena between them, her face ashen. The bailiff brought in the jury's note and handed it to Judge Ross. She read it aloud. "Can we watch Exhibit 12 again?" Ross glanced at the jury foreman, a middle-aged man in a cardigan who'd been taking meticulous notes throughout the trial. She nodded. "Yes, the jury may review Exhibit 12. Bailiff, please set up the playback." The jury filed back in. The lights dimmed. The 18 seconds played. The jurors watched in complete silence, some leaning forward so far they were almost out of their seats. When it ended, they filed back out without a word. David Carter looked at Elena. She was crying again, silently, her shoulders shaking. Carter put a hand on her shoulder but said nothing. There was nothing to say. 4 more hours passed. At 7:51 p.m., as the sun set over Lake Michigan and the courthouse began to empty of staff, there was another knock. This time the note said, "We have reached a verdict." Judge Ross's heart was pounding as she took the bench. The courtroom, which had been nearly empty an hour ago, was now packed. Word had spread. Reporters filled the back rows. Courthouse staff who had no business being there found excuses to slip in. Everyone wanted to see how this ended. Elena Cruz stood between her 2 attorneys, swaying slightly. Judge Ross wondered if she might faint. The jury filed in. Judge Ross had learned long ago that you can't read a jury. Some people say jurors won't look at a defendant they've convicted. That's a myth. Jurors look where they look. You never know until you hear the words. "Madam Foreperson," Judge Ross said, "has the jury reached a verdict?" The woman in the cardigan stood. "We have, Your Honor." "Please hand the verdict form to the bailiff." The bailiff walked the single sheet of paper from the jury box to the bench. Judge Ross unfolded it, read it once, read it again to be sure, and then handed it back to the bailiff. "The defendant will rise." Elena stood. Her attorney stood beside her. The courtroom was so quiet you could hear the heating systems hum. Judge Ross looked at the foreperson. "Please read the verdict." The foreperson cleared her throat. Her voice was steady but quiet. "In the matter of the people of the state of Illinois versus Elena Maria Cruz, case number 2024 CR 04471, on the charge of aggravated assault with a deadly weapon, we the jury find the defendant not guilty." For a moment, nothing happened. Then Elena's knees buckled and David Carter caught her. She was sobbing, hands over her face, making sounds that weren't quite words. Her daughter, who had been sitting with Elena's sister in the gallery, ran forward crying, "Mommy, Mommy, Mommy." The bailiff started to stop her, but Judge Ross waved him off. The little girl crashed into her mother's arms. Judge Ross waited for the commotion to settle, then addressed the jury. "Ladies and gentlemen, thank you for your service. You are dismissed with the gratitude of the court." She looked at Elena, still holding her daughter, both of them crying. "Miss Cruz, you are free to go. This case is dismissed. We are adjourned." The gavel fell. The courtroom erupted. Reporters rushed the defense table. District Attorney Nguyen gathered her files in silence and left through the side door without speaking to anyone. Judge Ross retreated to her chambers, closed the door, and sat in the dark for 20 minutes. She had broken a rule. She had admitted evidence that by strict procedural standards should have been excluded. And because she had, a woman who might very well be innocent was going home to her daughter instead of to prison. But the question remained, had she served justice, or had she just opened a door that should have stayed closed? The verdict came down on March 15th, The media coverage was immediate and intense. Chicago Tribune ran the headline, "Judge's Unusual Ruling Leads to Acquittal in Assault Case." The legal community was divided. On March 18th, the Cook County State's Attorney's Office issued a statement saying they were reviewing the case for possible appeal of the evidentiary ruling, though that would be complex given the acquittal and double jeopardy protections. But here's where the story takes a turn that nobody expected. On March 22nd, 1 week after the verdict, a man named Vincent Kozlowski walked into the Chicago Police Department's 9th District Station and asked to speak to a detective. He said he needed to confess to a crime. Vincent Kozlowski was 34 years old, a former line cook with a history of drug possession and assault charges. He had been in and out of county jail 3 times. On February 9th, he had been staying with a friend in an apartment 2 blocks from the Quick Mart on South Halsted. He told Detective Enriquez that on the night of February 9th, he had gotten into an argument with Marcus Whitmore in the Quick Mart parking lot. Whitmore had been his supervisor 2 years earlier at a different warehouse. Kozlowski claimed Whitmore owed him money from an old debt, approximately $800. When Kozlowski saw Whitmore at the Quick Mart that night, he confronted him. The argument escalated. Whitmore shoved him. Kozlowski pulled a knife. He slashed Whitmore's arm. Then he panicked and ran. He had been living in fear ever since, moving between friends' apartments, staying off social media. But then he saw the news coverage of Elena Cruz's trial. He saw her face. He saw her daughter. And he said he couldn't live with the knowledge that an innocent woman had almost gone to prison for what he did. Detective Enriquez was skeptical. False confessions happen. Sometimes people confess to crimes they didn't commit for attention, for mental health reasons, or because they're covering for someone else. She asked Kozlowski for details only the real attacker would know. Kozlowski described the knife, 7 inches, black handle, slight chip on the blade near the hilt. That detail had never been released to the press. He described what Whitmore was wearing, a gray jacket, jeans, white sneakers. That matched the police report. He described the sequence of events. Whitmore came out of the store. Kozlowski approached him from behind the dumpster. They argued near a blue sedan. Whitmore pushed him. He swung the knife. Whitmore fell. He ran toward the alley and threw the knife in a dumpster 2 blocks away. Every detail matched. Enriquez asked why Whitmore would identify Elena Cruz if Kozlowski was the real attacker. Kozlowski said he didn't know. Maybe Whitmore genuinely mistook him for Elena in the chaos. Maybe Whitmore saw an opportunity to retaliate against Elena for the harassment complaint and took it. Kozlowski had short hair, was about 5'9", and was wearing a light gray hoodie that night. In dim light, in a moment of trauma, Whitmore might have truly believed he saw Elena, or Whitmore might have lied. Detective Enriquez brought in the surveillance footage. She showed Kozlowski the 18 seconds from the loading dock camera. Kozlowski watched it and said, "That's me. That's the attack." Enriquez asked if he would be willing to plead guilty to aggravated assault. Kozlowski said yes. He was tired of running. On March 25th, the Cook County State's Attorney's Office announced that Vincent Kozlowski had been charged with aggravated assault with a deadly weapon in connection with the February 9th attack on Marcus Whitmore. The charges against Elena Cruz, already dismissed, would not be refiled. Kozlowski pleaded guilty 4 weeks later and was sentenced to 6 years in state prison. The media firestorm intensified. Now the question wasn't whether Judge Ross had overstepped her authority. The question was whether she had saved an innocent woman from a wrongful conviction. But the story doesn't end there either, because Marcus Whitmore gave an interview to a local news station. He said he stood by his identification. He said when he looked up during the attack, he saw Elena Cruz's face. He believed it then, and he believed it now. If Kozlowski was confessing, Whitmore suggested, maybe Kozlowski and Elena were working together. Maybe Elena hired Kozlowski. Maybe there was more to the story. The state investigated that theory. They found no evidence of any connection between Elena Cruz and Vincent Kozlowski. They had never met, never communicated, ran in completely different circles. The theory collapsed. Gerald Reed, the eyewitness, also gave an interview. He said he saw what he saw. He was 70 feet away, but he was certain. When asked if he might have been mistaken, given the distance and the fact that he wasn't wearing his glasses, Reed became defensive. He said his eyesight was fine. He said he was good with faces. He said he had no reason to lie. Eyewitness identification is one of the leading causes of wrongful convictions in the United States. Studies have shown that human memory is far more fallible than we like to believe. Stress, poor lighting, distance, and the passage of time all degrade the accuracy of identification. And once a witness commits to an identification, confirmation bias sets in. The witness becomes more certain over time, not less, even if the original memory was flawed. Gerald Reed probably believed he saw Elena Cruz. Marcus Whitmore probably believed it too, at least initially, but belief and truth are not the same thing. The 18 seconds of footage that Judge Ross admitted didn't prove who attacked Marcus Whitmore, but it created enough doubt to prevent a wrongful conviction, and 1 week later, the real attacker's conscience did the rest. David Carter said in an interview that without Judge Ross's ruling, Elena Cruz would be in prison right now. Even with Kozlowski's confession, getting her conviction overturned would have required months or years of appeals, and there's no guarantee it would have worked. Wrongful convictions are notoriously difficult to undo once they're final. Carla Nguyen declined to comment publicly. Privately, sources said she was devastated. She had prosecuted the case in good faith, relying on witness identifications that turned out to be wrong. It wasn't misconduct. It wasn't malice. It was the system failing, despite everyone's best intentions. Judge Meredith Ross also declined most interview requests. But in a written statement released through the court's public affairs office, she said this: "I made a decision based on the interests of justice as I understood them in that moment. I am gratified that the truth emerged, but I am also mindful that our system does not always allow for such outcomes." This case highlights the tension between procedural rules, which exist for good reasons, and the pursuit of justice, which sometimes requires flexibility. I leave it to others to debate whether I made the right call. The Illinois Appellate Court never had to rule on whether Judge Ross abused her discretion because there was no conviction to appeal, but the case became a teaching tool in law schools across the country. Professors used it to illustrate the limits of procedural rules, the power of judicial discretion, and the moral weight of decisions made under uncertainty. Some argue Judge Ross was a hero. Some argue she was a rogue judge who got lucky. The truth, as always, is more complicated. Let's step back and talk about what really happened here, because this case isn't just about one judge and one ruling. It's about systemic issues that plague the American criminal justice system every single day. First, eyewitness identification. Gerald Reed and Marcus Whitmore were both wrong. Not lying wrong. They genuinely believed they saw Elena Cruz, but human perception is not a camera. It's a reconstruction influenced by expectation, stress, suggestion, and bias. When police showed Reed a photo array with Elena's picture, his brain said, "This looks like the person I saw." Not because it was definitely her, but because memory is a process of pattern matching, and Elena's face was close enough to the pattern his brain had stored. The Innocence Project, an organization that works to exonerate the wrongly convicted, reports that mistaken eyewitness identification plays a role in more than 70% of wrongful convictions that are later overturned by DNA evidence. 70%. And yet juries find eyewitness testimony incredibly persuasive. There's something compelling about a witness pointing at a defendant and saying, "That's the person." It feels certain. It feels true, but it's often not. Second, discovery and late evidence. The rules that almost kept Exhibit 12 out of Elena's trial exist to prevent unfairness. Imagine if one side could spring surprise witnesses or evidence at the last moment, giving the other side no time to investigate or respond. That's not justice. That's ambush. But the rules assume perfect knowledge, perfect investigation, and perfect timing. In the real world, things get missed. Cameras exist that no one knows about. Witnesses come forward late. Documents surface years later. The rigid application of procedural rules in those situations can lead to absurd outcomes, excluding the truth in service of process. Judge Ross made a judgment call. She decided that in this specific instance, with this specific evidence, under these specific circumstances, the interests of justice outweighed the procedural inconvenience. She was right. But what if the footage had been less clear? What if it had shown nothing useful? Would she still have been right to admit it? These are the questions that make judging so difficult. Third, the prosecutor's role. Carla Nguyen did nothing wrong legally. She charged a case based on witness identifications and circumstantial evidence. She believed in her case. But the system places enormous pressure on prosecutors to win convictions. Conviction rates are used to measure success. Prosecutors are elected or appointed based partly on their ability to secure guilty verdicts. That creates an incentive structure that sometimes prizes winning over truth-seeking. There's a concept in prosecutorial ethics called doing justice, which means a prosecutor's job is not to convict at all costs, but to ensure the guilty are punished and the innocent are protected. In practice, that's a difficult balance. Once a prosecutor has charged a case and invested time and resources, there's psychological pressure to see it through, to believe in your witnesses, to discount exculpatory evidence, to view the defense's arguments as obstacles rather than legitimate challenges. Nguyen probably should have been more skeptical of Reed's identification. She probably should have investigated Whitmore's timeline more carefully, but she was operating within a system that rewards certainty and punishes hesitation. Fourth, the confession. Vincent Kozlowski's decision to come forward was extraordinary. Most people in his position would stay silent. He was looking at serious prison time. He had already gotten away with it. Elena had been acquitted. She wasn't in danger anymore. He could have simply disappeared, but he didn't. He confessed. And that confession is what ultimately confirmed that Judge Ross's instinct was correct. But here's the uncomfortable truth. If Kozlowski hadn't confessed, we would never know for sure. The jury acquitted Elena based on reasonable doubt, but reasonable doubt is not the same as proof of innocence. It's possible, in an alternate timeline, that the jury convicted, the appellate court reversed Judge Ross's ruling and ordered a new trial, and Elena went to prison without anyone ever knowing whether she was truly guilty or innocent. Justice is not a science. It's a process, and processes fail. 6 months after the verdict, Elena Cruz was working at a nonprofit that provides legal support to low-income defendants. She had become an advocate for criminal justice reform, speaking at community events about her experience. Her daughter Sophia was thriving in 3rd grade. Elena had started therapy to deal with the trauma of the trial. She said in an interview that she wakes up some nights still terrified that it was all a dream, that she's actually in prison, that Sophia is growing up without her. "I think about how close it was," Elena said. "If that camera hadn't existed, if Officer Blake hadn't cared enough to follow up, if Judge Ross hadn't been willing to take a risk, I'd be in Decatur Correctional Center right now. My daughter would be visiting me through a glass partition, and everyone would believe I was guilty because a jury said so." She paused, collecting herself. "People think the system works. They think innocent people don't get convicted, but I almost did, and the only reason I didn't was luck. Luck and one judge who was willing to bend a rule." David Carter, her attorney, left the public defender's office 4 months after the trial. He joined a private firm specializing in criminal defense. He said the Cruz case had changed how he thought about his work. "I used to think my job was to hold the state to its burden and poke holes in their case," Carter said, "and that's part of it. But the Cruz case taught me that sometimes the truth is hiding just outside the procedural boundaries. Sometimes you have to push. You have to fight not just for reasonable doubt, but for actual innocence. And you have to hope you get a judge who's willing to listen." Judge Meredith Ross continued to preside over criminal trials in Cook County. Her decision in the Cruz case was cited in 3 subsequent Illinois cases involving late evidence admission. 2 appellate courts upheld trial judges who admitted late evidence, explicitly referencing the Cruz case as precedent. 1 appellate court reversed a trial judge who excluded late evidence, noting that the Cruz case demonstrated the importance of judicial flexibility in the interests of justice. Ross was promoted to the Illinois Appellate Court in 2025. During her confirmation hearing, she was asked about the Cruz case. She said simply, "I made a decision I believed was right. I would make the same decision again." Marcus Whitmore never recanted his identification of Elena Cruz. He maintained that he saw her face during the attack, and that he believed she was involved somehow, even if Kozlowski was the one who wielded the knife. Without evidence of conspiracy, the state did not pursue further charges. Whitmore eventually moved out of Illinois. His current whereabouts are unknown. Gerald Reed also stood by his identification. When confronted with the fact that Kozlowski had confessed, Reed said he must have been mistaken about some details, but that he was certain he saw a woman with dark hair. When pressed on how certain, given the distance and lack of glasses, Reed became angry and ended the interview. Eyewitness identification experts say this is common. Once someone commits to an identification, admitting error feels like admitting to lying, even when it's just admitting to being human. Vincent Kozlowski is currently serving his 6-year sentence at Menard Correctional Center. He has been a model prisoner. He participates in educational programs. He expressed remorse in a letter to Marcus Whitmore, though Whitmore never responded. Kozlowski is eligible for parole in 2028. And the 18 seconds of footage that changed everything. It's archived in the Cook County Court Records, Exhibit 12 in case number 2024 CR 04471. Grainy, time-stamped, inconclusive. A perfect metaphor for the criminal justice system itself. Partial truth, imperfect clarity, and the hope that if you look closely enough, you might see what's real. So here's the question this case forces us to confront. Is breaking a rule ever the only path to justice? Judge Ross would probably say it depends. It depends on the rule. It depends on the circumstances. It depends on the stakes. Procedural rules are important. They create predictability, fairness, and due process. Without them, the system devolves into chaos where power and persuasion triumph over rights and evidence. But rules are created by humans, applied by humans, and sometimes, in specific cases, they lead to inhumane outcomes. When that happens, when strict adherence to procedure would result in an innocent person going to prison or a guilty person going free, judges have to make choices. Judge Ross chose justice over procedure. She admitted evidence that technically should have been excluded. She took a risk, and because she did, Elena Cruz went home instead of to prison. But imagine a different scenario. Imagine Judge Ross had made the same ruling in a case where the late evidence was less clear, where the defendant was actually guilty, and where the procedural violation was more egregious. Imagine the appellate court reversed, ordered a new trial, and the defendant went free on a technicality. Would we still praise Judge Ross for her courage, or would we condemn her for judicial overreach? This is the paradox at the heart of the case. Judge Ross made the right call because we know the outcome. Elena was innocent. Kozlowski confessed. The truth emerged. But at the moment Ross made her ruling, she didn't know that. She was operating on instinct, experience, and a gut feeling that something was wrong. She got lucky. The truth vindicated her. But luck is not a legal standard. Luck is not something we can build a system on. And yet, if we build a system so rigid that it cannot accommodate truth when it arrives inconveniently, have we built a justice system or merely a procedural machine? These are the questions the Cruz case raises. These are the questions every judge, every prosecutor, every defense attorney, and every juror must grapple with. Because justice is not a formula. It's not a flowchart. It's a human endeavor, flawed and imperfect, conducted by people doing their best in impossible situations. Judge Meredith Ross broke a rule. She admitted evidence late. She risked reversal. She put her reputation on the line. And she served justice. Or did she just get lucky? Maybe the answer is both. Maybe that's the uncomfortable truth. Maybe justice and luck are sometimes indistinguishable. Maybe the best we can do is create a system flexible enough to allow for human judgment, strong enough to resist human corruption, and humble enough to admit that we will sometimes get it wrong. Elena Cruz got justice. But how many others don't? How many sit in prison cells right now because the camera didn't exist, because the witness didn't recant, because the judge followed the rules strictly, because luck didn't break their way? The Cruz case is not a story of the system working. It's a story of the system almost failing and one person making a choice that prevented catastrophe. That's not sustainable. That's not scalable. That's not justice. That's a miracle. We need a better system, one that doesn't require miracles, one that doesn't depend on individual judges being willing to risk their careers to do the right thing, one that prioritizes truth over procedure without sacrificing the fairness that procedure provides. Until we build that system, we'll keep having cases like Elena Cruz's, close calls, near misses, wrongful convictions narrowly averted or, more often, not averted at all. Judge Ross broke a rule to serve justice. But the fact that she had to break a rule to serve justice is the real problem, and that's a problem we all need to think about, because next time, the defendant might not be so lucky. Next time, the camera might not exist. Next time, the judge might follow the rules. And next time, justice might not be served. This is the story of the judge who broke a rule to serve justice. A story about courage and risk. A story about procedure and truth. A story about the impossible choices judges make every day in courtrooms across America. A story about Elena Cruz, who almost lost everything. A story about Judge Meredith Ross, who risked everything to do what she believed was right. And a story about a system that got it right this time but might not next time. Because justice is not a given. It's a fight. And sometimes winning that fight means breaking the rules. The question is, should it have to be that way? That's the question Judge Ross leaves us with. That's the question Elena Cruz's case forces us to confront. That's the question we all need to answer. What is justice worth, and what are we willing to risk to achieve it? Judge Meredith Ross had her answer. What's yours?